Good morning, councils. You may be seated. Apologize for the few-minute delay. Getting some feedback. Test. Testing. Test. Okay.
And the other one, it looks like it's two speakers.
Testing. Okay. Will the clerk please call the case?
This is Supreme Court Case Number CRA24-006, People of Guam Plaintiff Appellee v. Ricky Santos Cruz, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Christine Santos Tenorio. Appearing for Defendant Appellant is Attorney Braddock Huseman. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Huseman reserves 10 minutes.
You may proceed, Mr. Hughes.
Morning, Your Honors. May it please the court.
Can you hold the mic up a little closer?
How's that? Good morning. May it please the court. Generally, fair trials require that the evidence match the allegations in the indictment and that the conviction of a crime is for the crime indicted and not for prior bad acts. Generally, evidence rules protect these rights. In certain cases, like the one at bar today, we have relaxed as a society some of these evidence rules, but the relaxing of these rules do not obviate the need for a fair trial, do not obviate the constitutional rights to a fair trial. Put differently, just because the prosecution can do something doesn't mean the prosecution should do something. Here, the government's actions denied Mr. Cruz a fair trial by creating a variance between the indictment and the facts proved at trial.
Are we limited to just considering the indictment, or could we consider sources other than the indictment, like the complaint, the information provided during discovery, the information provided during the pretrial hearings?
That information is available at the court as well. But the variance here created lack of a fair trial for two ways. One, there's lack of proper notice. And two, it places Mr. Cruz in double jeopardy, or the possibility of double jeopardy. And with my time today, I'd like to discuss both those. We're asking that the that the court vacate the three convictions that we've briefed and requested, and the court remand for a new trial.
Can we go over the variance? I want to understand, to make sure I understand the timeframes on the alleged variance. The timeline in the indictment said the 2015-2016 timeframe. The timeline in the magistrate's complaint said that, identified three distinct times, essentially based on what was described. One was when he touched the minor's vagina when they watched a video of an adult male touching another minor. One was when he touched the vagina when he called her into a bedroom. And then another incident was when he touched the vagina while they were watching a video with adults having sex with each other. I think those were and so it seems like the testimony or the evidence at the first trial indicated the first incident occurred when around 2012 or 2013, when she was 6 or 7.
I think that's
and in
correct.
the seventh grade. So, I mean, that's one that you say, clearly was a variance. And then the second incident, I think her testimony was that that occurred a year before the third incident and about a year or two after the first incident. And if we say the first incident happened in 2012 or 2013, that incident likely happened the third incident happened between 2014 and spring 2015.
It's possible, yes, Your Honor.
Yeah,
It's-
so
it's-
wouldn't that fit within the time frame of the?
So that third might, and part of the reason it could, but there's a problem here because all of these, all three were given the vulnerable victim treatment, which is retroactive to any crime before 2014. And as the court knows, that's not possible. That's the vulnerable victim is not a retroactive statute. And so the government wasn't confident enough in the timeline to allow those convictions to stand. And so it asked that at the end of the trial that those, even though they were submitted to the jury, not for the trial court not to consider those. And so while it's possible that the third of these acts gets close to something I think the court would accept as within the time frame, I think because the government's choices here, which were to put on the evidence of 4 basically identical issues, but then seek the vulnerable victim status, takes this in some way. Time does become an element of this offense, not for as an element, but because of the vulnerable victim charge. And because all those had to have taken place after 2014, and because the government abandoned all those, it creates this actual problem. And it created a catch-22 for my client, because at this point, if he pleads guilty, he can't honestly plead guilty to a crime that occurred in 2015 and 2016 with a vulnerable victim modifier. He's going to suffer under that vulnerable victim modifier, even though he can't truthfully plead to it. So it forces him to go to trial, but allows the government to use evidence of these crimes that occurred prior to what they're claiming. And the simple remedy for this would have been a superseding indictment. It's not that hard to get. It would have lined up the charges with what the government wanted to prove, and would have made a defense much more straightforward. But in this case, it puts the defendant is in the position of not being able to exclude crimes or actions or evidence that occurred prior to 2015, but suffering under increased penalties that aren't actually available. And that's why we say that the government's excuse that time isn't really a element of these cases, that's true. Time isn't an element, but when the government makes the choice to add the modifier and still not amend the complaint, it creates a problem for the defendant, and it's an unfair trial. It's difficult to present any defense in that case. Again, it allows the government to throw these allegations, throw these bad acts at him, and it makes it difficult to address his actual defense. It's not proper notice, which is our first issue. But it also puts
So what kind of notice do you feel would have provided your client with sufficient notice so that he can prepare for trial? I mean, you have the allegations in the indictment. You have the dates in which they are alleged to have occurred, and so I'm not following your thinking in reference to what is it that would have could have been provided that would have given your client proper notice.
Well, at this point, I think what proper notice is the correct time frame. It allows the attorney to have a frank discussion with his client. It allows the attorney to tell the client, as a defense lawyer, you're always put in the position where the state has, and this, obviously wasn't the trial counsel, but I've had these conversations before where a defendant might not have the most realistic view of his case. That's why he has an attorney to help to assist him with the view of the case. In this case, where the government is saying these things happened in 2015, 2016, where they're asking for additional penalties based on crimes that occurred in 2015 and 2016. Notice in this case is proper to put the crimes to remove the special modifier and to give the defendant notice of when the crimes actually occurred and when the government thinks they occurred.
But as stated earlier by Chief Justice Torres in the opening, your client had access to the magistrate's complaint, which provided there was a declaration by the Assistant Attorney General in which these acts were allegedly occurred. And through, as the transcripts show, pre-trial discovery, defense counsel was able to obtain information and the dates when these acts allegedly occurred and filed motion in limine and to exclude the testimony that was inconsistent with the indictment. And so I'm not seeing how the defense counsel was hampered in reference to not having specific dates, which I think you readily admit is not required under the statutes and Guam law. And so I'm not following how the variance of what's in the indictment, what testimony was testified at trial, and what was produced prior to the trial hampered the defendant from having information that would be sufficient to provide a defense in reference to the allegations.
And the hampering, I would direct the court back to this idea that the government is seeking this retroactive penalty, this vulnerable victim penalty. They're going to put this information in front of the jury, which is this is an attack on the law. This is an attack on presenting the jury with the idea that we're already going to allow these prior bad acts in front of a jury. We're also going to inform the jury and make them check a box and inform the jury that these crimes are serious enough that the people of Guam have decided that they deserve special modification. And because of 413, again, these rules are available. They can be used, but they were leveraged in this case. So it becomes, there's really not a defense at this point, and there's no alternative either, because the client can't plead honestly guilty to something that happened in 2015 and 2016 and then suffer under that modifier when that isn't what happened and the government knows that it isn't what happened. And that's why we say it's difficult to provide proper notice.
So, but the trial court, when it ruled on the motion in limine and denied it, didn't it put you on notice that that was the timeline that was going to be involved, right? But you're saying even with that timeline, they still were looking for this enhanced modification.
Yes, because they submitted to the jury, Your Honor. And so that becomes a problem. It's having, to use a phrase, it's having the cake and eat it too. I'm going to throw everything at you, even in stuff that I know I can't prove at trial, but I'm going to do it anyway. And when you're convicted, well, then I'll admit that the stuff happened prior to 2015 and it won't be a problem. Now, I'm not saying this was purposed. I mean, things happen at trial. It's very busy. Both the defense bar and the AGs have, you know, multitude of cases, and we're looking at this case, you know, in an appellate context. So this isn't an accusation, but it's an actual problem. And it's something that the trial court should have paid a little bit attention to as well, because you have a situation where the prosecution is asking for a lot. And I think the court under 413 does have discretion to do these things. But at some point, the trial court has to say, well, you can't have everything prosecution. If you're going to introduce these prior bad acts, if you're going to introduce if this is what you want to do, well, then reform your complaint or don't put any information about something that happened in 2012. Make your choice. And that would have forced the government to change its indictment.
So is it really an error on the instruction that was given to the jury as opposed to there being a variance in the testimony from the complaint, the magistrate's complaint and the indictment and the evidence at trial?
It's possible. I think that is a possibility. I think ultimately that it is a variance. It also could be an error in what was presented to the jury.
Yeah, but I mean, I think I tend to agree with you. There's a variance, but the question is, was it a material variance that jeopardized his
Notice.
notice? Was there adequate notice of the charges against him, and how did it impact his ability to prepare his defense? And then the double jeopardy issue.
Right.
So.
And so the double jeopardy, if the court doesn't accept that this was proper, or rejects the idea that he wasn't received proper notice, I still think there's a double jeopardy problem here. And the double jeopardy it's still based on this idea that all these crimes are alleged to have occurred in 2015 and 2016. As the court knows, any evidence the prosecution puts on about bad acts that happened in 2015 or 2016 are immune from further prosecution. The problem for the prosecution, and ultimately now the problem for Mr. Cruz, is that the government didn't put any evidence on of anything that happened in 2015 and 2016, and it put evidence on of things that happened between 2012 and possibly 2015. And so the prior bad acts that the government decided to put on, again, these are choices the prosecution made. There's no guarantee. There's, aside from a prosecution or the attorney general saying, well, we won't indict on this, but that's not the guarantee.
We're talking about the fourth uncharged incident?
Yes, Your Honor.
Yeah, but I mean, why doesn't our decision in Wesson control that? I mean, we basically said that the government can't bring re-prosecute offenses that occurred during the time alleged in the indictment.
Well, that's the problem, because the time alleged in the indictment is 2015 to 2016, and the bad acts occurred prior to 20. We're not even sure when this fourth incident occurred. We have a rough estimate, but it didn't occur between 2015 and 2016, as it's pointed out in the record, and I think in the supplemental excerpts of the record. Mr. Cruz was not in the house at that time, and I'm not even sure the room existed by 2015 or 2016, which is why and I'm going to butcher this, why we cited the Ninth Circuit case, United States versus Tisha Nahi, possibly. Sorry about that. But that's why Wesson doesn't cover this case, because the prior bad act falls outside the timeline. And since it falls outside the timeline, the court has to develop a rule for situations like this, because there is a hole here. GRE 413 does allow evidence of prior bad acts, but and this is why we're making this argument that just because some of these things are allowed doesn't mean that they are constitutional, that they satisfy those ultimate burdens. And here, these acts occurred outside the timeline. There's no guarantee that he cannot be prosecuted again for that fourth prior bad act, which is why Wesson doesn't apply.
Yeah, but if the government raised it, asserted it, although it may not have charged it, you're saying hypothetically that that's a double jeopardy issue because potentially it can be charged. I mean, those events have not occurred.
Nope. That's true, Your Honor.
And so it's hard for me to speculate that because of this assertion, but not charged, but reference that potentially it's a double jeopardy issue. What do we do to address that if it hasn't occurred?
Well, the well, I'd have to go back and look at Wesson, but I don't think it had occurred in Wesson either. And the court said, well, no, it falls within the timeline. Well, here we're falling outside the timeline. There is a hole in the court's case law. There is a hole and not, I mean, this is a new thing. This is unique as far as the case law that I've looked at. So the reason and part of the problem here is this you're entitled not to stand trial twice, and the government's behavior has created a situation where it is possible for him to stand trial twice. And so we're bringing it to the court's attention.
But it's possible. And if that possibility is alleged in a subsequent indictment, then wouldn't that be the appropriate time to file a motion for dismissal, violation of double jeopardy? And because, you know, it's speculation that it will even be charged at a later date.
I would concede that, but I would also point out that at this point, at some point, we do not want to make due process the punishment. And so I understand the court's question. There's a guarantee that an individual won't stand twice for the same crime. He's already sat once, but it falls outside of all this court's and every other court that I've looked. I don't know of any court that says bad acts that fall outside of an indicted timeline are not indictable or qualify as double jeopardy. So the situation, what the court is saying, or excuse me, what the question seems to be indicating is, well, this is possible for the court to deal with it at a later time. And while that is technically true, the court then is also subjecting Mr. Cruz to an entire another trial and double jeopardy is not just the ability not to be convicted, but it's not to be tried.
I understand that.
And as soon as that indictment is brought, he's going to be sat for, he's going to be put in the defendant's chair. And that is what I would say is something the court in its discretion should examine and cut that off at the pass. But that is, of course, the court's choice. I've reserved 10 minutes. I see that I've cut into that a little bit. If the court has no other questions, I'll reserve the remainder of my time.
Thank you, Mr. Hughes. Ms. Tenorio?
Ms. Tenorio, is it your position that the government acted in good faith in bringing this indictment?
Yes, Your Honor. I'm
Then
sorry.
why does the magistrate complaint say 3 acts happened one day after another in 2012 and you indicted for 2015?
Understood, Your Honor. Before I continue, I think I only have 20 minutes, so I just want to correct the timer. Okay. Your Honor, this was brought in good faith. The Supreme Court has recognized that young children don't
But-
remember dates.
But
And
why in your complaint do you say these acts happened one day after another in 2012 and then charged in 2015?
So if you look at the complaint, the original statement from the victim is it happened one day after another, but she gave differing dates. She said either 6 years prior or 4th grade. And so if you actually do the calculation, that's how the prosecutor got to the 2015-2016 timeframe.
I don't understand that. It says she was born in 2006. If she was 6 years old, that's 2012. And if you take,
So she said 6 years prior. was the issue. She didn't say she was 6 years old in the original complaint, because I had also looked at that issue. She said 6 years prior, so 6 years before 2021 was 2015. And so at the time, the prosecutor had to have a choice between, we didn't really know the precise date, because she said 6 years prior to that date or fourth grade. But then we had a confession, and I know that appellate counsel says that it shouldn't be part of the record, but it actually is a part of the record, the confession, because the defendant placed it at 2011 or 2012. So this is a case where he acknowledged that he did it. He's just saying the government got the time wrong because the victim was so young and couldn't remember the date. So in good faith, we charge it based on her rendition of the events, not his, because we have to go by the complainant. So that's why we charged the 2015 to 2016 time period. And then it became clear when we were preparing for trial, the victim's memory, she put it in chronological order, and it's the same exact acts, same order of events, but she was remembering a slightly different time period, that's where the 6 to 7 years old comes in. So that information was not garnered until the interview where we prepared for trial, which again, the defendant got notice of.
But then why include the special allegation?
So I want to clarify something about the special allegation. The special allegation itself doesn't make reference to any time periods. It just says if the victim is under the age of 13 years old, automatically vulnerable victim applies. But what had occurred was that whoever did the indictment, and even the court and the defense attorney, didn't notice until after the trial, the date of enactment was 2014. So there is a confusion there, which is I'm the one that alerted the prosecutor. I actually checked the timeframes, and I said, because this was enacted in 2014 and our indictment says 2015 to 2016, but we knew that there was a difference in the time dates. That's why we sua sponte dismissed all of the special allegations at sentencing.
Yeah, but that was at sentencing. What about the argument that he was prejudiced in terms of evaluating whether to accept a plea agreement or do a plea in light of the special allegation?
So this is going to take, there is evidence in the record. He was set to plea, and he was set to plea to a way, way low sentence, not even first degree, not second degree. He was set to plea. He was going to enter a plea, but then they took the chance to go to trial. So I don't think he was prejudiced, because in the plea, the special allegations were always going to be dismissed. And in the end, you don't suffer if the modifier, one, is not used, but two, in this case, everything ran concurrently anyway. So even if here the appellate counsel is only actually disputing 3 of the 4 charges, even if it's reversed or remanded on that issue, which I believe is not error, it's the same sentence because it was run concurrent. So I understand Mr. Huseman's argument that he believes that it affected his ability to enter a plea, but I do not believe that, because in the end, because of the reasons I just stated. And so, again, to clarify for the record, the facts in this case were that she just did not remember the date, but when you get to trial, that's when you remember the date. However it comes out is however the government has to take it. Now, this is not a true variance, though, because as indicated by this court in prior decisions, a variance is if it is a fact that's different. It's an act that's different. And the reason in this case that the trial court let this go forward is because the government was very clear it was the same exact acts. She described it the same way each time, but for that 4th uncharged incident. And so she had very descriptive, and we were correlating each act with exactly what she said. The very first time it happened under the window. And then the second one was when there was a movie where it was a pornographic video of an adult with a minor. And then there was a pornographic video with 2 adults. The only uncharged act, and the reason why we know it was the uncharged one, it was because the zombie movie came in the second interview, but he was not charged for that. So again, this is a situation where the government is in a difficult position where the victim cannot remember the exact date, but because we know the victims can't remember the exact date, any time that we can give the defendant the benefit of the variance being after 2014 because of the modifiers or even some sentencing enhancements where it can't be suspended, where it's after 2015, we actually do give them the benefit for that reason. So I don't think that the client suffers if the government concedes at sentencing that any variance would we wouldn't use against him essentially. So in this case, the defendant did not suffer by the extraneous acts because he did prepare his defense. His defense was threefold. One, I did this, just not on the date they said I did. And counsel acknowledged that because it came out in evidence that he apologized for the incident, but he apologized for a 2012 incident. One, two, he said it was factually impossible, which the jury, I want to talk about the construction of the bedroom. The only evidence in the record about the bedroom walls being broken down was from the victim, and she said that had occurred later when she was in 5th grade. So the defense actually did not put up any evidence that the bedroom was not there. They said it in closing, but it was not entered into evidence. And then 3, he just said he didn't do it, except even though he had apologized. So here, the indictment sufficiently differentiated between the counts here because the indictment made very clear that it was at a time different from count 1, at a time different from count 2. And this court has stated that if the government differentiates in that way, then that is sufficient. And so appellate counsel would like the government to put who, what, where, when, and why. That's the rule that he's proposing, but we're just not obligated to do that under the current case law. And we're also not obligated to put time and location. So contrary to what appellate counsel says, where we should have put the location or in the indictment as in Taitano, Taitano specifically said we don't put the location in indictment. And I just want to I want to say something about the plain error review there. So my argument was twofold. They cannot attack the indictment for lack of notice. They actually, in People v. Bossi, this court said that you waive any attacks on the actual wording of the indictment if you don't do it before. You can still, if it's not before trial, you actually waive it. So actually it's waived, but this court can also consider under plain error review under Felder. So that's why I put those standards of review there, saying if he thought it did not sufficiently differentiate, he should have brought a bill of particulars, but they didn't.
But in terms of looking at our standard of review here, I know you're arguing that it should be plain error.
Only for the his issue with the complaint was not sufficient notice, but it's de novo, I agree, when you look at it under a double jeopardy analysis under the Fifth Amendment. It's just differing depending on what issue we're talking about. But if he wanted, my argument is this, if he wanted to attack the indictment before trial, he should have, but he did not. But he is allowed to attack the lack of notice.
Motion in limine. Attacking the time frame, and he did also make the continual objection to the introduction of any evidence prior to the timeline in the indictment.
Agree. I'm talking about the indication that they want a location in the time in the actual indictment, or the act in the indictment, or the specific details in the indictment. So I do agree, though, that it is de novo review when we are talking about the double jeopardy issue. Now, the defendant cites to the Valentine case to say that they should be on notice. We should be putting specific incidents, and the to wit language is not enough. But again, that does not apply. This court has held the generic charging is sufficient notice when you can look at the pretrial discovery and the magistrate's complaint to see what you are being charged with. And I want to say too about the extra act. So to the issue of the jury instruction. So the reason why they had a bench conference on this, the activities not charged jury instruction was not given because everyone was, the argument by the prosecutor was it was the same act. So the trial court didn't want to give the activities not charged because he's like, that's going to confuse the jury, because if these are the same acts, even though it's a different time frame, then that's just going to confuse the jury even more. So on the issue of double jeopardy, I did cite to, I think the solution is, and I cited to the West Virginia case, if an act is charged and it varies from time frame, the rule is that the prosecution is barred from prosecuting it. So while appellate counsel believes that that is the prejudice that his client suffers, no, we are barred from charging anything that was talked about during any of those time periods, whether or not it was confined to the 2015, because of the variance. So it's a variance in the sense that it was a different date, but it's not a true variance because it was the same exact acts that he was charged for.
I want to go back to the argument that the alleged variance impacted his ability to enter into a honest plea agreement. I know you talked about the plea negotiations gave him a better sentence or a sentence, I think it was 8 years with 5 suspended. But the problem was the dates were still including the vulnerable victim enhancement right? The dates were still 2015 and not the 2012 dates.
Understood, but here's the other issue. So I broke it down, the timeline. I actually think the only charge that is can be considered variance is charge 1, count 1.
I think count 2 also.
But if you, so when you view the evidence in a light most favorable to the people, right? So if this is a sufficiency standard, which even though sufficiency is not disputed for purposes of double jeopardy, you can entertain that. If she said that the first act was in 2012 or 2013, her testimony was the next act happened 1 or 2 years later. Well, that puts us, if we're using the conservative year of 2013, then 1 or 2 years later is 2013 to 2015. And he was actually charged with January 1, 2015, and it's on or about that date. So that would go
Yeah, but
charge
her
1, count
testimony
2.
was also that the third incident occurred between 2014 and spring 2015, right? Or that
2016. So the second incident, we places it 2013 to 2015. The third incident is 2014 to 2016, but the entirety of January of 2015 is charged, and then partial of 2016 is charged. So actually, her testimony did include the years in question, and I believe that's actually why they submitted the defense about the walls being down, because even by her testimony, even whether there was a variance, she still put it at least the third incident between 2014 to 2016, and the jury could have acquitted on that charge if they believed that the walls were no longer there. So if you view all of that evidence conservatively, the only charge or count that is outside the time period in question is the first charge, count 1, of touching the primary general area, because she placed that at 2012 or 2013. So I actually believe that we're really only here for that 1 count if you view the evidence in the light most favorable to the people and break down her memory of the dates in that manner. And so if we do that, then I still don't believe that the 2012 or 2013, based on the case law that I put forward, there's case law out there that says a variance either 2 years prior or 2 years after a date that's charged is not fatal. So I put forth that case law. And also, he couldn't have used that defense anyway for that charge, because he couldn't say that the 2015 he couldn't have happened because 2012 he was still living there. And I actually do want to talk about that defense. Just because you don't live in a place doesn't mean that you didn't go there. And there was testimony that even though he didn't actually live there, he would sleep there a lot. So the jurors took all of this evidence about the discrepancy of the time and found that these incidents did happen. So they were very clearly explained why 2015, 2016, it was explained, yes, we know that the dates are off, but because time is not an element, because of the children's memory issues, that was sufficient to go forward. And so, again, I cited case law where it says, even if someone puts an alibi defense or defense where the defense that's tied to the time, a sex offender cannot be insulated because of a child's lack of memory. So, in this case, the defense knew that she was having issues with the date, so then they tie it to the defense and then try to claim variance so that they can get an acquittal, except that he had confessed and apologized. And it was always for the same incidents. This child was never saying it happened So unlike Wesson, she's not saying it happened 20 times every year. She's saying there is these specific incidents that I recall, and that was it. And so the jury, I don't believe there's a unanimity issue. They were given a unanimous jury instruction. They were given at that time 5 delineated incidents because he was charged with 4 counts. And I don't think anything regarding her touching his penis is disputed, so that count still stands. So that's where we are when we're talking about the jurors and what they were able to find. Now, and the defendant cannot claim surprise because, again, that is why he filed the motion in limine. So he was already able to avail of that, and he had time before trial to restructure the defense, but he still used the defense of the time anyway, which they're allowed to do. And this court has stated the discrepancy in time goes to the weight of the evidence, not admissibility. It's fodder for cross-examination of the victim, which they did. They extensively cross-examined her on the time, but she was very clear about the acts that occurred. And so in this case, I don't believe that it's different from the other cases that this court has considered. For the additional act under People v. Wesson, that additional act is like People v. Wesson, a surplus of one act is not fatal to the variance. I mean, it's not fatal. It's not fatal. And so even though there was one uncharged act, we actually wouldn't, it fell under 413. And even though the judge did not believe that it was a different act, the trial court still analyzed it anyway under the Chanel factors to preserve that for later. And so I believe that even if we're reviewing under abuse of discretion, the admission of that act into evidence, there was not an abuse of discretion. It was harmless error to enter the act because the act was even the uncharged act is part and parcel of the girl's timeline. So in that case, those cases, we cannot sanitize the victims and say, hey, don't tell the jury about the timeline of this one event because we're not allowed to. It's part and parcel of it. We're barred from re-prosecuting it because because it was not charged in the original magistrate's complaint. And the government is never required to go back to the grand jury for superseding indictment. And actually, I don't even believe we were going to be allowed to amend the indictment. So Mr. Huseman believes that we should have amended the indictment and we wouldn't have had an issue. But that was the very issue, is if you amend the indictment, that's saying the charge is different. But the charge was never different because it is the same 3 acts of touching the primary genital area and 1 act of touching the penis. So it was not necessary to amend the indictment, one, because then they would have said, oh, see, they're admitting that it's a different act when it wasn't. And we're not required to go back to the grand jury just to get a superseding indictment that alleges a different timeline because the time is not an element of the offense. So in that sense, the indictment was sufficient. They put him on notice. He was on notice. He used that to his advantage by filing the motion in limine. The trial court excluded or denied the motion in limine, and the jury was able to hear the evidence in this case. And so the defendant is not prejudiced because he was able to mount all 3 of his defenses. And the modifier, again, that's not something that was done in bad faith about removing the vulnerable victim. Again, that inured to the defendant's benefit that prosecution even caught that before sentencing. And I don't believe that the presence of a modifier somehow prejudices the defendant in front of a jury because the element's the same. When you explain it during closing arguments for sufficiency purposes, you say, here it's under 14, but hey, there's a law that says if you're under 13, there's this extra allegation. They're not given the statutory penalties for it, so they can't take that into consideration. So I don't believe that it presented it in a way where she was more vulnerable than if we had not included the vulnerable victim special allegation, because it was just precisely due to her age, which is under 14 under first degree CSC, but under 13 for the Vulnerable Victim Act.
I think your time's up.
Yes, Your Honor, thank you.
Thank you, Ms. Tenorio. Mr. Huseman? You have 8.5 minutes.
So with regards to the plea agreement, I was in trial counsel. I can't speak to what the plea agreement was or what he was offered, but I can speak to on the cold record that I have in front of me and what the court has in front of it, that the government was charging him with special allegations. I don't know what the underlying, what they would have waived, what they wouldn't waive. But the point here is he can't plead guilty to something that falls under the special allegation and can't truthfully do it. As far as whether the special allegations applied to 2 or 3 or all of the charges, you can't, I don't think the prosecution or the government can have it both ways. They released or they dismissed all those charges after they were submitted to the jury because they weren't confident that they fell within the timeline and they weren't confident they were going to be applied retroactively. And it is the standard that defendants get at this court, which is the light most favorable to the prosecution. Well, if prosecution actually believes this, then why did they dismiss all 3 as opposed to this, all 3 of the special modifiers as opposed to just 1 or 2, if that's what they thought they had, and made the same argument here. They dismissed all 3 because there is some ambiguity here, and it would be a denial of due process to enhance a conviction based on a retroactive application of the law. And these are kind of the problems that, again, the rules of evidence have been relaxed in these kind of cases that allow this kind of thing to happen. And what I'm asking the court to do here is to consider, just because some of these things are allowed, the defendant's rights still have to be protected. The process cannot become the punishment. And in this case, we're looking at the government knows that some of these things happened in 2012 and decided that they weren't going to get an indictment. I'm not a criminal trial lawyer. I cannot tell you the ins and outs of amending. I've never been a prosecutor. I cannot tell you the ins and outs of amending an indictment. I can only do what I did, which is cite you to the Guam law that allows for an indictment. And there didn't have to be new charges completely. They just have to be the correct dates.
If the original plea agreement did not include the vulnerable victim enhancement, how was he harmed by not being able to enter into? You're just saying because it was false for him to admit to those dates?
Well, yeah, then it would only be if the vulnerable victim enhancement isn't part of that, because that is part of the argument, Your Honor. Then it becomes
Well, it wasn't.
It's a weaker argument.
The plea agreement was 8 years with 5 suspended.
I believe that to be the case, but
Yeah, so it didn't seem like the vulnerable victim enhancement was included in that plea agreement.
it might not have been. But I think the guilty plea is still to those things. And yeah, the court or the government doesn't necessarily.
Those are the dates.
The government doesn't necessarily have to enhance on a plea deal. That's true. But you're still asking the defendant to plead guilty to something that it amounts to a legal impossibility. And to the extent that it's, like I said, I would concede that it's a weaker argument without the vulnerable victim modification, but the facts are here what they are. So that is the issue.
Well, let's say there was no vulnerable victim, but asking him to plead to a crime that occurred in 2015, but the crime really occurred in 2012. And he knows it occurred in 2012, but he agrees to plead even though it says 2015. You're saying he he couldn't honestly do that.
I'm saying you can't honestly do that. That is still a problem because as counsel for the government pointed out, variances that we're usually talking about here are 2 years on either end at the max. And you're asking the defendant to plead guilty to the additional. And then part of the other problem is with or without, with the special modification, that, like I said, it does become a problem. But even without, you're asking the defendant to allocute to something that is basically a legal impossibility. And so we're supposed to be getting this right. Like I said, I agree that I'm not alleging bad faith. I'm just saying that everyone's busy, but at some point these facts have to be lined up correctly or we end up with some troubles. And that's why we're here today, to try and fix these troubles. The government's choices in this case created this variance. The indictment, it varies from the facts presented. That violated Mr. Cruz's right to a fair trial. We're asking for this court vacate those 3 convictions and allow a new trial. And if there are no other questions, I'll rest.
All right, there are no further questions. The court will take the matter under advisement and we will issue a written. Thank you.
All rise.